Hello, good afternoon, everybody. Welcome to this new life sciences session here at ALTIUS with the fantastic title, Prescription for Cyber Protection, NIS2 Compliance in the Life Science Industry. During the next hours, I, Jan Clinck, as speaker of the day, will enlighten you about the challenges and the compliance issues regarding this new piece of legislation. So what do we have on the agenda for you? First of all, we are going to set you the scene. What is NIS2? What is its aim? What is the background of this legislation? Then we go to the scope. We have a look at the obligations, and we will finalize with the questions regarding enforcement. If there are any questions, of course, you can put them in the Q&A and I will try to answer them afterwards. Or you can, of course, drop me an email after this session. As already an introductory takeaway, we go from NIS1 to NIS2, which is actually, let's say, a NIS 2.0. We are going to have a broader scope, more and stricter obligations, and also stricter enforcement. And that I will show you in the next slides. If we look at the aim and the background of NIS, which is an abbreviation for Network and Information Systems, we see that the starting point for the European legislator goes back to 2016. At that moment, he recognized and acknowledged that those systems were vital today because of their reliability and security. They are essential for the activities within certain sectors. And if such sectors would be hit by cybersecurity incidents, that could have a major threat for economy and society in general. And because cyber threats are becoming more frequent and their impact is a lot higher than before, such regulation was highly welcomed. So that's when NIS1 saw the light. It was the first legal set of rules on cybersecurity at an EU level. We are now 8 years later. We are getting back to NIS2, but in the meantime, also a lot of other cyber-related legislation has come up. I can mention a few like the DORA, which financial institutions will get very familiar with these days. We can expect in the nearby future also the Cyber Resilience Act. So it are very good times for people looking at cybersecurity issues. Talking about issues, there were issues with NIS1, and that's why we have a NIS2, or in 2 weeks' time, we will have a NIS2, because quite soon after NIS1, it became apparent that it was quite obsolete and too narrowly scoped. There was still an increase in cyber threats, and because of society and the economy becoming more interconnected and dependent on digital services, there was more need for clarity, because NIS1 lacked actually clarity with regard to scope, with regard to competences. The enforcement was also insufficient. I can't recall any decisions from Belgian authorities related to NIS, certainly not any fines, and also because it was a directive and thus implemented in the different member states, there was a lot of discrepancies between the national enforcement and the national approaches. And so those were the challenges that NIS2 nowadays will try to address. So the aim is the same as with NIS1, but let's say we go to the next level of cyber security in the EU. With regard to the legal framework, it actually has the same pillars NIS1 and to adopt NIS2 even today. So a member state struggling with the implementation. And the Belgian legislator has also already come with a royal decree that was in June 2024, clarifying more rules about the competent authorities and about the reference frameworks. I'll talk to you about those issues later in this session. NIS1, you can forget about it in 2 weeks' time. Then it will become NIS2 and this new set of rules. So, first question, when do we fall under NIS2 and what is its scope and what is, of course, the impact for the life science sectors and for the entities in such sector? When we have a look at the scope, we can see that it's refined and extended, and that we have 2 new types of categories that are introduced compared to the first NIS1 legislation. For those who were familiar with NIS1, there we had 2 annexes. We had an Annex 1 that was enumerating the essential services, and we had an Annex 2 which was focused on digital service providers. And in Annex 1, the healthcare sector was mentioned as one of those essential services. For NIS2, we still have 2 annexes, but the approach is slightly different. There is a 2-step approach that will bring you to a qualification as either an essential entity or an important entity, or you fall outside of the scope of NIS2, of course. I hear you think, what are those essential entities and what are important entities? Well, essential entities are entities that are active in the sector of Annex 1. That's the so-called sectors of high criticality, of which, of course, healthcare is one, besides water, gas, digital infrastructure, transport, and so on. It's not only sufficient to have an activity within a sector of Annex 1, you also have to qualify as a large company to be an essential entity. Next to the essential entities, we have important entities. Important entities can be both under Annex 1, so delivering activities in a sector of high criticality, or under Annex 2 when they're delivering services in other critical sectors. If they are under Annex 1, it will only be medium-sized companies. If we talk about the sectors of Annex 2, it's focused on the medium-sized and large companies that will qualify as important entities. In other words, we have a 2-step approach. 2 questions you should ask as an organization. First question, do I provide services under Annex 1 or Annex 2? And for the life science sectors, you should first of all look at the activities that are related to the healthcare sector. I get back to you on that in the next slide. Second question is, am I a medium or large enterprise? Because if not, if you qualify as small or micro, you fall outside of the scope of NIS2, a few exceptions set aside. Which gives us this other overview. You're only an essential entity, and essential entities, they will have the most far-reaching obligations if you are a large entity and you provide activities from Annex 1. if we have a look at the activities of Annex 1, and more in particular, the healthcare sector, we will see that the scope has broadened. Under NIS1, only healthcare providers could be identified as operators of so-called essential services. Under NIS2, this has changed. We still have healthcare providers, so they still fall within the scope of NIS2, but we have 4 additional categories that will also be impacted. We have EU reference laboratories, we have entities in research and development of medical products, entities manufacturing basic pharmaceutical products and pharmaceutical preparations, and entities manufacturing medical devices considered to be critical during a public health emergency. Some items still have to be clarified about what's the scope of each of those subsections. So we already got questions about what about pharmaceutical products related to animals. Would they also fall within the scope? My first approach is that yes, this will be the case because there is no distinction made between pharmaceutical products for animals or for human beings. It seems that both categories will be covered. That was the first step. The second step was you have to do a size calculation, let's say, and that should be in accordance with the rules that you can find in the EU recommendation from 2003. This recommendation holds the rules how to calculate your size as an enterprise. I don't go into the details of how this calculation should occur. I think what is important to know is that if you have less than 50 employees within your organization, you will fall outside of the scope of NIS2 because then you will qualify as a small or micro organization. If you go above the threshold of 50 employees, between 50 and 249, you can qualify as a medium organization if your turnover reaches also a certain threshold. And if you go above 250 employees, together with the other conditions, you can qualify as a large entity. What's very important to know is that the size calculation of the enterprise is broadly interpreted. So an enterprise also encompasses the partner and linked enterprises. So if the Belgian establishment, yes, would be part of a larger organization, also the numbers of employees and turnover should be taken into account to calculate the size of this Belgian organization, which will more quickly, of course, trigger the scope of NIS2. One important exception in Belgium, the legislator has chosen to. What does this mean? It means that if the organization, the entity established here in Belgium, would be a small or medium enterprise, and he would be independent with regard to cyber risks, cyber security, and cyber security management, the numbers of the partner and linked enterprise should not be taken into account, meaning such entity falls outside of the scope of NIS2 and should not comply with this set of rules. So this is an important one to take into account. And this is also an important one to check also in other member states if your organization has establishments there. One last point that is interesting to notice about the scope is that we go from a system of identification to a system of self-registration. Under NIS1, you could only become an essential entity if you fall within the activities that were determined as such. But Also, only if you were identified as an essential entity by the sectoral authority. That has now changed. Now every organization has to do a self-assessment and should assess whether or not it falls within NIS2 and whether or not they qualify as an essential or important entity. If that's the case, they should report and they should register with the CCB, so the Cybersecurity Center of Belgium, and provide the legally necessary information. Deadline is not 18 October 2024. You have 5 additional months, so until 18 of March 2025 to comply with this registration obligation. And this brings me needless to our third chapter, the obligations. On this slide, I have put an overview of the different obligations that we identified in the NIS2 Act, together with a timeline when to comply with each different obligation. You will see that most of them will be triggered as of 18th of October. That will be the case for the significant incident reporting, for the adoption of the appropriate cybersecurity measures, for the training of management bodies, but I guess this will actually in practice be a little bit later if relevant authorities would request information or if you have to collaborate with them. Later on, by March 18th, you should register with the CCB, and in 2026, April 2026, you should comply with the regular conformity assessments, and in April 2027, you should have obtained certification. I get back on this last one in a little bit. First, let's have a look at this obligation of incident reporting. Incident reporting was already known under the NIS2 Act, but now it has a little bit changed the scope. It has become, of course, broader, and it's more, let's say, a more GDPR-like approach. So under NIS2, significant incidents should be reported. So there is a certain threshold. If we compare it with GDPR, every data breach should be reported with the data protection authorities. That's not the case with NIS2. Only significant incidents should be reported. When do we talk about such incident? Well, that's the case when the incident could cause for the entity severe operational service disruption or financial loss, or with regard to third parties, it could cause considerable material or non-material damages. If this would be the case, this triggers a reporting obligation. Timing is, of course, of the essence when confronted with a significant incident. As before, so as already was the case under NIS1, you should report without undue delay. But what's new under NIS2, there are stricter deadlines, and there is a, let's say, three-step approach. Within 24 hours, you should make an early warning to the authorities. Within 72 hours, you should make an initial assessment. So even if you don't have all the details, you're still implementing measures, you should make a report and inform the authorities about the steps that you have already taken. And within 1 month after this initial assessment, you should provide the authorities with a detailed report. And the deadlines, they start as from the moment that your entity becomes aware of the incident. Whom should be notified and informed about those significant incidents? Of course, first of all, it should be the competent authority, so the CSIRT, which is part of the CCB, as many of you will know. But what's new under NIS2 is that there is also an obligation to notify service recipients. When? Well, only if they are potentially affected by the cyber threat with which you are confronted with regard to the incident. And then in such case, you should provide these service recipients with the measures that they can take to mitigate the risks and to protect themselves against such incidents. And if appropriate, says the law, you should also inform them about the threat itself. So additional information obligations can be found in NIS2. Second obligation is, of course, having sufficient technical and organizational measures in place to face cybersecurity threats. Under NIS1, this was very generally regulated. The basic premise was, of course, take adequate and sufficient technical and organizational measures. And this included having a NIS security policy. And if you would opt for compliancy with the ISO standard 27001, you could get a presumption of NIS compliance. These elements are now more enforced, more brought to a next level, let's say, because under NIS2, the basic premise is, of course, the same. You should take adequate measures, both on the level of technical, operational, and organizational level of your organization, with the goal to manage cybersecurity risks and to prevent and minimize incidents, both with regard to your own organization as with regard to recipients of your services or other services. How to assess whether or not your security level is appropriate? Well, take into account the state of the art, says the law, take into account the standards, international standards and European standards, but also implementation costs. So getting to a sufficient security level should not be done at all costs. You should take into account that your budget allows you to take certain security measures. What measures to take? Well, therefore, you have to look at the risks that your entity can be confronted with the size of the entity, and with the probability and the severity of the risks. NIS2 is focused and emphasizes the all hazards approach. So you should take into account all risks that you could be faced with. So both to protect your network and information structure, but also physical environments. And to help you with this, the EU legislator has come with a list of minimum measures. There are 11 minimum specific measures that were mentioned in the EU NIS2 directive, starting from different policies with regard to risk analysis, incident handling, business continuity, but also supply chain security, security of your network and information system acquisitions. There is also a focus, of course, on policies and procedures to assess the effectiveness of cybersecurity risk management measures, to use cryptography and encryption, to enforce within your organization cyber hygiene practices and cybersecurity training. You should have a look at human resources security, your access control policies and asset management, and also introduce use of multi-factor authentication or continuous authentication solutions. So that's already quite a specific list to help organizations to know what measures to take or on which measures to focus. Know that the Belgian legislator has added a 12th measure, which is required and which is to come up with a policy for coordinated disclosures of vulnerabilities. What's important to notice is, I believe that there is a focus on supply chain security. So this brings, in my opinion, a new due diligence obligation. You can compare it with what we have seen with GDPR, so the relationship between a controller and a processor, by which a processor agreement was necessary, and you had the obligation as a controller to only use adequate processors who could guarantee a sufficient level of security. Here it will actually be a similar obligation. You should guarantee that your own service providers can comply with the minimum cybersecurity requirements of your own organizations. And probably this will lead to contractual guarantees that your service provider, although not in itself required to comply with NIS2, should comply with these requirements. And for instance, you should request from him an ISO certification regarding NIS2 compliance or any other guarantee that gives you comfort to know that this service provider gives you an adequate level of security. The Belgian legislator has been very kind because in the royal decree, he has identified what he calls reference frameworks. And so these frameworks are tools to help you measure if the measures that you will implement are adequate and will get you to the sufficient NIS2 security level. And there are two reference frameworks that are mentioned in the royal decree. One is the Cyber Fundamentals framework. That is a framework that is developed by the Cybersecurity Center of Belgium itself. And next is the well-known ISO standard 27001. Both frameworks play a high role or an important role when we have a look at the obligation of the conformity assessments. For essential entities, there is an obligation, a mandatory obligation to conduct regular conformity assessments. For important entities, that's not the case, but they can voluntarily adopt such conformity assessments. What's the upside of such assessments? That if you have a certain certification, this will give you a presumption of NIS2 compliance. To get to that point or to conduct such conformity assessments, there are different options for an organization. We have the Cyber Fundamentals framework, we have the ISO 27001, which I already mentioned, and there is also the option of having an audit by the inspection service of the authorities itself. If we have a look at these different options, and if we have a look at the timings for the regular conformity assessments, and I noticed that I made a slight error in the deadlines, so that should be 2 times the 18th of April and not the 26th. I will fix that after this session. But if we have a look at these 3 options, let's say 3 swimming lanes, we have a deadline in April 2026 and a deadline in April 2027. And so by April 2026, depending on the swimming lane that your organization would choose, you have to provide certain documentation already to the authorities. By April 27, if you choose for one of the two reference frameworks, you should have obtained a certification. If you would choose for an audit by the inspection service, you should provide by April 2027 an update of your progress of conformity process. In the next slides, I have taken 2 screenshots of this Cyber Fundamentals compliance tool, which is accessible on the website of the CCB. So it's an Excel file with an introduction, how to use this tool. And with then below, you will find different tabs. And the 5th one is with regard to the healthcare sector, which gives you this assessment tool. And you will see in the far right corner that there is the Cyfun level basic. There are 3 categories. You have basic, important, and essential, which goes back to the qualification that you can have under NIS2. And based upon this tool and the answers that you give and the size of your organization, you will reach one of these 3 cyber security or Cyfun levels. And depending on which level you have to take certain measures. Last obligation on which I want to focus is obligations for management within an entity. So overall, we can say that management should be more involved with regard to cybersecurity. So they have the obligation to approve the cybersecurity risk management measures, and not only to approve them, but also to oversee the implementation of those measures. They are personally liable and responsible that these are complied with and that an organization implement sufficient NIS2 measures. And that's also why the NIS2 Act obliges these members of governing bodies or executives to follow relevant cybersecurity trainings. And also they are encouraged to provide such trainings to employees. Goal is, of course, that everybody within an organization becomes more, let's say, more familiarized with cybersecurity incidents, that they are quicker triggered by such incidents, and that they can respond more adequately if such incidents would occur. This brings us to enforcement. What about enforcement? Well, key player with regards to enforcement remains in Belgium the Cybersecurity Center, but he will get help. He will get help from sectoral authorities. The different sectoral authorities are already identified in the Royal Decree. If I recall correctly, there are 5 or 6. And when we have a look at healthcare, we see that there are 2 different sectoral authorities, depending on the activities that your entity would provide. It would be or the Federal Agency for Medicines and Healthcare Products or the Minister of Health. And thus, both the CCB as those sectoral authorities have certain competences. They can request information, they can issue binding instructions, but they can also conduct inspections, both on-site and off-site, even conduct dawn raids and audits, security scans, and of course they can come with sanctions. Sanctions means, of course, also fines, and the fining mechanism has altered compared to NIS1. Under NIS1, we can say that it was quite a weak regime. Maybe the sanctions would go up to 200,000 euros, but in practice, that did not often happen. And now we see more GDPR-like administrative fines. So the fines got bigger, meaning that for essential entities, they can face administrative fines up to 10 million or 2% of the annual global turnover, whichever is highest. And for important entities, it can go up to 7 million or 1.4% of the annual global turnover. In addition, there's also the risk of being imposed with periodic penalty payments. That with regard to any payments that should be made as a sanction, there are also, of course, other types of sanctions like warnings that can be issued, compliancy orders to cease certain practices, or to designate a temporary monitoring officer to inform the public or to inform third parties on potential cyber threats. So you will acknowledge that this has become a more stricter enforcement regime. Which brings me actually already to the end of this session. The goal was to give you an overview of the scope and the obligations and what if you would not comply with those obligations. If I would have a quick recap and certainly look at the impact for the life science sector, in general, we can of course say that there is a much more global accountability. The scope is much larger, so more life sciences entities will have to comply because there are more activities encompassed under the notion of the healthcare sector. So that's a first step, a first assessment that each company has to make. When we have a look at the cybersecurity measures, there is a larger set of rules. There should also be taken into account the risks for third parties, which leads to, unfortunately, more IT resources that should be focused on cybersecurity, and also more people and technical knowledge that will be needed. That need is also required at the management level. They should be more involved, and they should also be more skilled and more knowledgeable about what cybersecurities there are, what incidents their organization can face, and they should take the time to train themselves in this manner. I also mentioned this new obligation of due diligence. So with regard to your service providers and the supply chain, there will be obligations, or there will be a review whether or not your own providers can provide you with sufficient and adequate technical and organizational measures so you yourself can comply with the NIS2 requirements. This will lead to new audit requests, probably contractual guarantees, and incitement for out-of-scope companies to increase their cyber awareness. If we had a look at the notification obligation, there is a lower threshold, there are higher expected reactiveness. Remember the 24-72-hour deadlines and then 1 month to report or to deliver your final report to the authorities, which will undoubtedly require more paperwork, and probably also within your organization, the implementation of adequate policies. And finally, as put on the previous slide, supervision has also increased. There are many more powers. There are higher fines, higher scrutiny. So we can expect concrete enforcement more than we had before under NIS1. And time will tell how the CCB, in collaboration with the sectoral authorities, and then in particular for the life science sector, the FHMP, will handle cases and how they will deal with possible infringements and with their inspections. If there are any questions, I'm happy to answer them in the Q&A or afterwards via email. Thank you very much for your attention and see you next time. Bye.